May I please, Your Lordship, Lord, appearing in this matter, and Lord, today for Your Lordship's kind consideration are 3-4 applications, Your Lordship. If not, I may start not by giving a brief background of the litigation and what has happened till today, Your Lordship. May kindly have
preliminary objection.
Yes.
Before my learned friend, can I just point out? I have moved a civil application. The suit was filed originally by my learned friend. Thereafter, he moved an application for amendment. The defendants filed their written
Suit for?
Suit is an Admiralty suit.
So that is, yes.
Which according to us is a defective plaint. So while we filed our written statements, defendants 1, 2 and 3, I also filed an Order 7 Rule 11 application seeking rejection of the plaint. In the meanwhile, the plaintiff moved 3 amendment applications one after the other.
Because it was defective?
Our submission is a
No,
defective.
his
My
submission.
Which in our submission was a defective plaint. My application under Order 7 Rule 11 is also with Order 1 Rule 10 that in the alternative delete me as a defendant. Now the question will therefore arise whether his amendment application should be heard first, which are 2, 3 in number. Should my Order 7 Rule 11 be heard first? So that for deciding that I have moved an application that please hear my Order 7 Rule 11 first before his application for amendments are taken up. Because in the event the amendments are granted, it may render infructuous my Order 7 Rule 11 and it may end up curing the defects which we are alleging under Order 7 Rule 11. So my application for that purpose is CA 1 of 2024. So that
I have filed a reply to that. Not in my.
So CA 1 of 2024 is to be heard first. Order 7 Rule 11.
My CA 1 of 2024 can be taken up to decide which should be heard first, these amendment applications or my Order 7 Rule 11.
Lord, I have a preliminary objection to the very movement of that application. How so? Lord, number 1, Lord, it is for this honorable court to decide which application is to be taken up first, not for anybody else. Number 2, if not the court, Lord, I am the dominus litis, I am the plaintiff, Lord. Lord, why I say so, Lord, that why amendment applications and my application for impleadment of party should be heard first. Lord, the basic grouse of my learned friend, respondent number 3, is that he says that I am an agent of a principal whom I have disclosed. And as per 230, the suit is bad. Lord, I say that, Lord, section 230 of the Indian contract per se does not bar the suit. It only says that the enforceability of the suit or the decree thereof cannot be effected against him. There are precedents. I'll read. Just a minute. I'll read precedents to that effect, saying that maintainability is not cannot be touched on that ground. However, cannot be any effective result against him. Not why he is to be kept pending and why he is to be maintained here. Not I'll give a reason also.
General first principle would be applicable that Order 7 Rule 11 is required to be heard.
I will, if your lordships, if this court wants to hear that first, I have no objection. I have absolutely no objection. But what I say is, Lord, the very section my friend is relying upon, saying that he should be let off, Lord, that very section says that if the disclosed principal cannot be sued, then he is to be sued.
But then how would you meet with his submission that suppose, assuming for a moment that your amendment applications are considered and they are allowed, would that not frustrate their first contention that the plaint was defective and therefore the plaint is
I will satisfy that also, that the plaint was not defective, and that is why, your lordship, what I was trying to do at the very beginning was to give a brief background. If your lordship date wise has that background, your lordship can decide which application is to be taken up first. I leave it to this court.
I'll take up Mr. Vakil's application first.
Yes, your lordship, but kindly allow me before.
Understand. He will also give the basic idea about the.
Yes, but Lord, allow me first to give the brief narration of facts, Lord, because I am the dominus litis at least. Lord, if that courtesy can be.
Please, sir. If you have any objection, if he.
Dominus litis does not mean that.
Yes, right.
Because principally that the plaintiff will decide whom he wants to sue.
Impede. That goes to the
right of audience.
No, it is not that. But he said that at least I will be listening you only with regard to the factual background.
Yes.
That with the, but what? Just a minute. Let me. Now I have heard you. Just Mr. Vakil, what your contentions with regard to your application?
Yes.
Your application?
If my application is OJCA 1 of 2024.
Huh.
Now, if my loss
Please, Mr.
also
Jain, have a
has
seat.
simultaneously
Please have a
because
seat.
of the
Please, sir.
plane only for a minute.
Let's see, you have in this civil application.
I have given the chronology of application which are filed from time
Let's
to
go
time.
to that applications.
Yes, if my loss
Is
can
that
just have a
first application, yours.
Yes, if my loss
1 of 2024.
If my loss can please have a look at page 2, para 2.1
Of your application?
of my OJCA 1 of 2024.
Yes.
Papers.
Yes, I'm
Para 2.1. My loss is para 2.1.
Yeah, I'm.
Yes. So the plaintiff filed the caption Admiralty suit on 1/8/2022 against the defendants with the following prayers. My lord, may please note the prayers now. The plaintiff therefore prays, pending final adjudication and determination of the present suit, the Honorable Court be pleased to direct the defendants to release SM systems and deliver it to the plaintiff. Now this is in the nature of an interim relief. The plaint must contain a final relief. The pending final adjudication and determination. For the defendants to pay the requisite charges to the tune of so and so till the time final damages are assessed.
So there is no
this,
final
in my
relief.
opinion, this in my opinion is a defective plaint.
So there is no final relief claim.
No, there is a plaint with no final relief.
Just a minute.
This is something in the nature of an Order 39 Rule 1 and 2 application.
This is in nature of?
An interlocutory relief which can be prayed under Order 39 or Order 38 or Order 40, for example, when it is a receiver. Now when this suit is filed, thereafter the plaintiff filed para 2.2 on 22/8/2022 civil application for amendment number 1 of 22 under Order 6 Rule 17 with a view to bring on record certain developments that had taken place after the filing of the suit. The said CA contained the following prayers that this honorable
So during pendency, OJCA 1 was filed.
Yes.
After filing of the plaint.
Yes. Now, therefore, I am now going chronologically. First, the suit is filed
on
one
after
the other, separate civil applications. The first civil application is 1 of 22. The prayers at page 3 that this honorable court be pleased to pass an order permitting the applicant to amend Admiralty suit being Admiralty suit 29 of 22 as proposed in paragraph 3 and 4 of this application for such other and further reliefs. Pending that application, the defendant numbers 1, 2 and 3 filed the written statement, para 2.3. Then para 2.4. Defendant 3 filed...
So you filed your written statement in relation to the main...
The plaint as it stood.
It stood.
Why I filed
no amendment. No, because it was not allowed.
Yes, it was pending. And secondly, there is a statutory time limit within which
you need
on the
to...
commercial side we need to file our written statement. Otherwise, my defense will be struck off. Then OJCA, I filed OJCA 2 of 22 under Order 7 Rule 11 and under Order 1 Rule 10. My reliefs are to reject the plaint by defendant number 3 or in the alternative to strike out the name of defendant number 3 from Admiralty suit 29 to pass such other and further relief, etc. Then OJCA 3 of 22.
Why you want to delete name of
the alternative, Lordship, because if the plaint can't be rejected, the plaint normally is rejected as a whole. So if the plaint
if it is
rejected as a whole, then delete me as a party for the reasons I have stated in my application.
So it would amount to same. His plaint would become infructuous because otherwise, to whom he will claim the reliefs?
I am D3. There is D1, there is D2.
Who are D1 and D2? Are they represented by someone?
Yes, they are representing the written statements are filed.
Who represent? You represent?
He is now sought to be joined effectively in lieu of me.
I
just come to that. So let us just complete.
So at present, no.
That is why I was saying, Lord, allow me 5 minutes first.
Understood. The D1 and D2 are yet not represented by.
They are represented and they have also filed the written statement. Mr. Nirav Thakkar is for defendant number 1 and Darshan Vadnani is for defendant.
So why they are not present today? No, see, I'm on the aspect that I consume some, this hearing may consume some time, and after that it may happen that it is required to be adjourned on account of their presence. So
So my guess why they are not present is because they may be
Order 7 to 11 will be first one.
11 is to be heard first. What is to be heard first, and then they are not concerned. I am taking up this plea.
Suppose today the relief is claim against, for my understanding, that defendant number 3 is required to be, let's say you test my name may be striked out. Assuming for a moment that accepting your contention it is striked out, then the claim would survive only for
defendant
1 and 2. Who are
my
they?
learned friends prayer to join my learned friend Mr. Harsh Parekh's clients.
Who are they?
They are the
consigning. In his agreement application says
Hmm.
that I'll just read out the agreement application because I would want to. He says that on base.
May I just give 5 minutes?
Just one. I'll give you audience, please.
He says that my client, defendant number 4 and 5, would be the owners of the vessel, and therefore he seeks to join me as parties.
Hmm.
That is his case.
You are the owner.
Yes.
So claim would you are
I am
your
supposed to
capacity.
be representing the vessel here.
Okay, so you are that consignee of
No,
The-
not the consignee. The agent's
agent of the vessel.
Agent in India.
Age vessel's agent
It's
is.
an agent of a disclosed principal. He is the principal, alleged principal, and the alleged agent.
So that is his case. That
So when I
is-
came up with this plea, he moved an application that let me join him as Mr. Parekh's client now.
And that is in his application also it says solely based on the averments of my learned friend's reply that I will be the owner.
There's no claim.
So there is no, in fact, his amendment application.
Otherwise, as I've seen that you are the agent in India to carry the vessel. So generally, the claim is always made against the owner of the vessel as well as the defendant. One defendant would be the owner of the vessel. And
It is an action in personam. It's not even an action
Right,
in rem. When the suit is initiated against the vessel and persons interested in the vessel come in, put security, and then the suit carries forward. This is an action solely in personam, where all the parties are joined independently. There are known defendants. The vessel is not joined as a legal
Entity.
person and legal entity. So if let me assume if there is a theoretical chance, let me assume 50-50 chance that such a plaint cannot be filed, which contains only interim relief. And I want to say at the threshold,
but would that not frustrate the relief, even if against the vessel?
but
that would be-
the vessel is not a party.
At this moment, it is not a party, but either his claim would go against you, or his claim would go against the vessel of the owner of the vessel.
Either this plaint is defective, irrespective of who are the defendants.
It will go.
Can the plaintiff file a suit saying that pending the adjudication of the suit, give me this relief? There is no final relief in the plaint. Now, if such a plaint, in my opinion, cannot be filed, there has to be a final relief. Either a declaratory relief.
No, the
or a-
purpose of asking you, suppose, assuming for my understanding that the court is with you, that let you be released from the area of defendant number 3, then is it open for him to raise his claim against defendant number, proposed defendant number?
Just say the question. Either my first plea is accepted, that the plaint cannot be filed in such a fashion, then the entire plaint goes. If my lords are not with me on the first aspect,
The
then
second
my lords feel that no, such a plaint can still be maintained, only with an interim relief, then my plea in the alternative is, for the reasons that I have set out, delete me as a
So
party.
that's what I am asking you for the second part.
Yes.
That suppose the court feels that you are required to be deleted from the area of the parties, then would his plaint be maintainable against?
The relief sought in the plaint ultimately is kind of joint and several. The reliefs are not directed only against defendant number 3. The reliefs are directed against all the defendants.
Before joining him as a party, then
Before
they are.
him as a party. But there are other 2 defendants against whom also the prayers have prayed for, maybe interim in nature. They are still prayed for against all the defendants. So it's a kind of a joint and
understood.
several.
Please continue. This you were pointing out this 2.4 you were reading.
Okay.
Strike name that you completed. 2.5.
Yes.
Thereafter
The
3.
OJCA 3 of 2022 by plaintiff the plaintiff filed on 12/12/2022 civil application for amendment number 3 of 22 under order 6 rule 17 containing following prayers. Now further amendment. So this is the second application for amendment.
So second amendment.
Thereafter, the plaintiff filed on 6/3/2023 OJ civil application so and so. However, copy of the said OJCA was never served on the applicant defendant. Appears that the said CA was thereafter disposed of, deregistered. Copy of the status report is annexed at so and so. The plaintiff then filed on 23/2023 OJCA so and so 2 of 2023 under order 6 rule 17 of CPC praying for following reliefs. Allow the plaintiff to amend the accompanying Admiralty suit in terms of paragraph 10 to 14 of the present application.
So this is a
Third
third.
amendment application. It's like something like this, little on the lighter side. કે મને પરીક્ષામાં બેસવા દો સર. હું જ્યાં સુધી પાસ ના થઉં ત્યાં સુધી મને બેસવા દો. હું જ્યાં till the time I give a good answer sheet, let me go and giving my exams. So he's going on giving amendment applications. Till he is satisfied that no, now my claim will be good enough to be sustained. 3 amendment applications.
So he's improving his plane now.
That is what I am trying to submit now. And then should that be allowed at the cost of my order 7 rule 11 and or order 1 rule 10?
So everything happened after your
Exactly.
defense statement.
Yes.
So that is the catch. That is
the catch.
that can that be allowed after filing of
Right,
your.
Lord.
So, net down 2.9. Just
Two-
give a brief so that at least
2.4.
2 point.
Sorry.
So
2.9.
2.9, 2.8. I looked at that application once.
2.8 not.
2.8.
Thereafter, the plaintiff filed OJ civil application for impleadment. That is to implead Mr. Harsh Parekh's client. Under order 1 rule 10, praying for the following reliefs, allow the plaintiff to implead the proposed defendants 4 and 5 as defendant numbers 4 and 5, pass such other and further orders.
What
Then
does
2.9. The plaintiff has preferred OJCA 3 of 22 for amendment, OJCA 1 of 2023 and OJCA 2 of 2023 for amendment, OJCA 3 of 2023 for impleadment. After the present applicant D3 filed OJCA 2 of 22 under order 7 rule 11 and order 1 rule 10. Thus it is obvious that the impleadment application and the amendment applications have been filed to cure the defects in the suit of the plate highlighted by the defendant number 3 in OJCA 2 of 22 seeking rejection of the plaint or deletion of the defendant number 3 from the suit. The applicant D3 submits that it is
so your prayer would be 222 may be heard first.
That is my only prayer for this application.
This application. Yes. Let me hear it so that at least.
Obliged, Your Lordship. But I'll be giving a brief background of how this litigation came into being, Your Lordship, by giving a few dates.
Just today you just narrate that why his application number 2
Yes, but that is the reason.
1 of 20, which application? 1 of 2024. It
Yes.
not be considered.
Why-
was-
Yes.
See, today I am considering his application
Absolutely.
either to accept or to
Absolutely,
reject.
absolutely, Lordship. Lord, for that also, Lord, I would have to give a few dates only,
Yes,
Lordship.
please.
Lord, to understand actually what the matter is, why those applications were moved. My friend has read what applications were moved, but what is more important is why they were moved, under what circumstances, what transpired. So, my Lord, I am the largest producer of spandex in India. Spandex is the material used in sportswear and swimming wear, Your Lordship. Lord, we were under an expansion drive. My unit is in Baddi, Himachal Pradesh. Lord, so we ordered a part of some machinery. Lord, we ordered big plant from China. Small part of that machinery was coming from China. Lord, the invoice of that part of big machinery was 12th of May 2022. It was called SM Systems. Cost was $8,28,850, amounting to some rupees 6 crores 95 lakhs 90,246. So, Lord, on 21st of June 2022, bill of lading for the ship OOCL Charleston was given to us, Lord, and the ship sailed from Shanghai for Mundra port in Gujarat, Your Lordship. And it arrived on 13th of July 2022 at 1 p.m., Your Lordship. Lord, on 14th of July 2022, we are informed that when the doors were opened, the pallet on which our part of machinery was located, it could not have been in a container because it was too big. So that had moved during travel and it was damaged. And my lord, after we were informed that your cargo has been damaged, 6 crore 95 rupees cargo is damaged, they say, you please give us rupees 59 lakh 10,000 because the ship has been delayed at Mundra port and some other things have been caused because of your
Who number the
all, Lord, number 1 and 2, your lordship. And thereafter, Lord, to get our cargo released, we file the present Admiralty suit. At that point in time, since we have not even seen our cargo, we do not know as to what has happened to our 7 crore rupees. We seek that the cargo may be released to us, and Lord, or in the alternative, the ship may be arrested. Lord, this court, while the first order, Lord, which was issued on 4th of August 2022, notice of motion said that you please pay the amount subject to the outcome of this petition and you get your cargo released. Lord, we approach them with a copy of this court's order. They say instead of rupees 59 lakhs, you pay us rupees 34 lakh 64,000 something odd rupees, and you please take your cargo
So
off.
that correspondence or that is with relation to number, not with Mr. Vakil's client, because at that time you are having claim against owner of the vessel.
Yes, yes.
Owner of the vessel.
We filed a suit against respondent number 3, thinking that he is the owner of the vessel. Why? Lord, during the course of the suit and Lord, the proceedings thereof, Lord, I will show a number of email conversations between my client and his client showing that he is acting as the principal and not the agent. It is not clear.
But to
Just a
whom-
minute.
To whom you have entered into, you must have, for carrying of that cargo from Shanghai, you must have entered into contract with someone.
1 and 2.
To whom?
1 and 2.
So-
1 and 2 are people who hired respondent number 3 on my behalf. Respondent number 1 and 2, based in Ludhiana and Bombay, they hired respondent number 3 who is based in Bombay.
You are aware of entire proceedings that the cargo is to carry through the vessel of the defendant number
But
1.
three.
But 3.
We were not knowing. Kindly, I'll read the plaint itself. The plaint I am saying everywhere, respondent number 3 is the owner. And Lord,
Owner of what? Respondent number
owner of OOCL Charleston, the ship. That is what I am saying in my plaint all along. That is the belief I have, and that is how I filed this civil suit. And the civil suit says, since I do not know what is the damage to my cargo, I am seeking liberty that at a later stage I will amend my petition and tell as to how much damage has been caused, and I will seek that damages from him. Because I do not know, I have not even seen my cargo. Therefore, the first payment that I make, the correspondences that I have in pursuance to the first order passed by this court,
with whom?
with the port and with the authorities, that on the basis of that order only I got my cargo released, your lordship. So I had
You
to
have not corresponded with 1 or 2.
1 or 2 also,
One.
because the invoices were raised by 1 and 2 only.
Yes. So
The amount was actually
the contract is with 1 and 2.
the amount was paid to them through them only, and he has raised, respondent number 3 has raised those invoices through them. I ultimately paid that amount and brought that on record by having moved the first amendment application that in pursuance to the first order passed by this court, this amount has been paid, my cargo has been released, and these are the documents which I have come into possession, and this is what all has happened. It was necessary. So I moved that application, notice of motion has been issued, has not been allowed till date. Now, your lordship, after having moved that application, respondent number 1 files first his WS 4/9/2022, and then on 4/11/22 the application order 7 rule 11 is moved. This is for the very first time.
Just a minute, what is your difference in you are owner?
It is defective. I am denying the fact that I am the owner.
You are
And I
owner.
have placed evidence to that effect. It is therefore that he says that solely based on the averments in my order 7 rule 11 that he has moved a fresh application.
No, I'm only asking you a question that right on your defense statement, what is your say that are you owner? Are you
Not
accept?
you.
No, you are still maintaining
That he is the agent.
You can-
That he is the agent.
Agent.
That he is the agent. Well, so he moves a WS on 14/11/2022, CA2 of 2022. Along with that, Lord, there is an application for Order 7 Rule 11 saying that Section 230 Indian Contract Act says that if you are the agent of a disclosed principal, the suit cannot go on. Lord, I file a reply saying that suit can go on against you. The section reads like this, and it is only the enforcement of the civil suit that cannot be against you, but you can still be proceeded against. And there is Bombay High Court, Calcutta High Court in Admiralty jurisdiction saying so, that 230, even the Supreme Court saying 230 of the Indian Contract Act does not bar making him a party. Only enforcement is precluded. And the Bombay High Court goes on to say, if the disclosed principal cannot be pursued, cannot be sued, then he is to be sued. Because where would I go?
But you have already sued.
Whom? I have
But
sued the owner. Just a minute. I have sued the owner. The owner comes up and says, I am not the owner. I am the agent. You please sue X and Y. I plead X and Y. So that application also becomes necessary.
So is it the case of defendant number 1 that I am not the owner, you sued defendant number 3?
Defendant number 1 and 2 were never the owner. I never said defendant number 1 and 2 are the owners. Defendant number 3 is the owner. I have said from the very beginning.
No, you said that I entered into a contract.
They are shipping agents.
Shipping agent. Mr.
1 and 2 are also shipping agents. Ultimately,
Who is the owner of the vessel?
Lord, ultimately, he discloses to us that I am not the owner. Owner are number 4 and 5. So we implead them, 4 and 5. If he says I am not the owner, they are the owner, we implead the owner. Now kindly read Section 230 Indian Contract Act. What does it say? That is the most important thing. Now Lord, I say,
see, your claim should be specific. You cannot say that my claim is now not against X, I'll go to Y. Why? After that you said that it's
Lord,
not Y,
there is
I go to
OOCL. OOCL is a company which owns the ship. Just a minute. OOCL is a company which owns the ship. It has an India website. Lord, that website. No, Your Lordship, no. I have filed, apart from my reply to the to his application under Order 6.
231. Today we are only deciding his application.
Yes.
Whether his application is required to be considered by granting him the hearing of Order Rule 710.
What is to be heard first? What is to be heard first? So, Your Lordship, may I kindly have 230 Indian Contract Act.
Yes, please.
Lords are there, Your Lordship?
Yes. Please.
May I read for Your Lordship?
Yes, please.
Yes. 230. In agent cannot personally enforce nor be bound by contracts on behalf of the principal. Lords are not there.
Please.
Yes. But it reads, in the absence of any contract to that effect, an agent cannot personally enforce contracts entered into by him on behalf of his principal, nor he is personally bound by them. That is it. Presumption of contract to the contrary. Such a contract shall be presumed to exist in the following cases. 1. Where the contract is made by an agent for sale or purchase of goods or for merchant residing abroad. Merchant residing abroad. 2. Where the agent does not disclose the name of the principal, that is not the case. 3. Where the principal, though disclosed, cannot be sued. So, my lord, number 1 and 2, presumptions to contract to the contrary are very important. 1. Where the contract is made by an agent for sale of goods for a merchant residing abroad. This is not a sale for. This is not a contract for sale of goods. And Lord 3. Where the principal, though disclosed, cannot be sued. Now, Your Lordship may kindly have his application only. His application CA2 of 2022 and the page thereof. This should be page 4 of his application. CA2 of 2022. Internal page 4.
Yes, please. Yes.
Yes. Lord, para
2.9.
3.2. 3.2 at internal
Just
page
a minute.
4.
This is Madhubina.
My lord, will
You are-
take up OJCA 2 of 2022.
OJCA2 of 2022.
Which is my order 7.
I accept OJCA 2 of 2022 વાળી સાથે નથી.
My application under Order 7 Rule 11.
Rule 11.
2 of 20, 1 of 24 છે.
Yes. kindly have internal page 5.
That is the application you are seeking to.
Yes. Not why I am seeking to read that particular point is in light of that section 230 only, my lord.
Please.
My lord, internal page 5, if your lordship.
Please.
Not right at the bottom. Additionally, the bill of lading at the bottom states as follows. Not there should be 1, 2, 3, 4, 5, 6, 7, 8, 9. Ninth line from the bottom. At page 5.
Please.
Lords are there.
Yes.
Additionally, the said bill of lading at the bottom states as follows. The contract evidenced by this bill of lading is governed by the law of the People's Republic of China. Any claim or dispute must be determined exclusively by a court in People's Republic of China and not any other part. So in a way, while moving his application under Order 7 Rule 11, he is also saying that I cannot be sued and even my principal cannot be sued. Very well. So, my lord, now I say kindly have the Indian Contract Act 230 once again in light of this averment made by him in Order 7 Rule 11.
Please read again.
But
230.
230. 230 once again. Presumption of contract to the contrary. Main part we have read already.
Yes, please.
So, your lordship.
Sorry.
My learned friend continue. It appears that my learned friend is now trying to demonstrate the merits of my Order 7
Yes.
to 11.
Yes.
No.
He wants to argue
No.
Order 7 to 11, that can be fixed. That is precisely my opinion.
No, Lord, what I am saying is, by reading these parts, why I have read a part of my.
I'm definitely considering that let's order
Just a minute.
7 Rule 11.
Before your lordships make up my lord's mind, allow me a few more things what I want to say. Not because tomorrow.
Decisions to that effect also, Mr. Vakil.
Sorry?
That Order 7 Rule 11 is required to be heard. Any decision, there are decisions to
I am trying to rely upon judgments which say that an amendment which takes away the right of a defendant should not be granted. There are, well, independently lordship under Order.
No, there are judgments also to the effect that this is to be heard first.
Should be heard first. The very object of Order 7 is to reject claims which ought not to occupy the time of the Honorable Court. So, if that is the principle, then Order 6 Rule 70, which takes away the right of a defendant to file an Order 7 Rule 11, because Order 6 Rule 17 is a plaintiff wants to amend the plaint and thereby cure the defect which has created a right in the defendant to seek rejection of the plaint.
See, assuming for a moment that he might not have preferred any amendment application,
Yes.
then his plaint would not have survived because it doesn't
By
contain.
submission.
So that is a first principle which you are applying
Yes.
by your submission, that if the
That's
amendment
exactly what
application
I'm
is not allowed, then the question posed to this court is that would that plaint be survived in absence of any final release?
And Lord, my rebuttal to that would be that since at that point in time when I moved the plaint, I had no possession of my cargo, I was in no physical or practical position to calculate and ask from this court, this is the damage to my cargo and I want to seek such damages from him.
But that can be considered when he argue his 711 application.
Yes. Lord, now my friend's humble submission, that if my applications are heard first, his some right would be taken away. So, Lord, my submission in that regard would be, Lord, what are my applications? Lord, the first application would be that I have brought on record that this amount was paid. Just a minute. That this amount was paid in pursuance to your lordship's order. The cargo was released to me. The cargo I got assessed, and this is the cargo reached my place at Baddi. We called a person. This much of damages we have paid. This much of thing was damaged. Just a minute.
What's your good name, please?
Abhishek Sethi, your lordship.
Mr. Shetty, that you are contending today is the circumstances which you have faced. Suppose Order 7 to 11 is heard, then why should I hear your other applications? That also will be come into place. That suppose his application is decided to be heard first, then to what extent your amendment applications are required to be considered?
Yes, Lord, because tomorrow, what prejudice would be caused to me? Lords are saying that only. Lord, I'll tell what prejudice would be caused to me, and I'll also demonstrate that no prejudice would be caused to him also. This argument is twofolds. One, no prejudice would be caused to him. That is the first limb of the argument. Number two, what prejudice would be caused to me? First, I'll come to the second part. What prejudice would be caused to me? Say today we allow him to go and continue with the suit because ultimately my cargo has been damaged, Your Lordship, and the amount is not also that little. And tomorrow, the proposed respondent number 4 and 5, who have been served, who have filed some sort of pleadings also, they come up and say,
No, understood. But they come and say that no, actually,
the jurisdiction is in China. Then, Your Lordship, rule section 230, this 3 would come into play. When he cannot be sued, then respondent number 3 would have to be sued. So therefore, and also, my Lord, I'll read a judgment of the Bombay High Court saying that Section 230 of the Indian Contract Act does not bar the filing of the suit against respondent number 3 being agent of a disclosed principal.
Mr. Shetty, today actually I'm sorry, Mr. Shetty, I am running short against time because there are at 2:30 I fixed many of the election petition. You just do one thing that you just jot down your points and the page on which you are relying with the plaint. Today the issue is whether his application is required to be considered first or not. Same, Mr. Vakil, that so far as the application is concerned, you have pointed out that this is the chronology. But why your application is required to be heard first? Because the amendment application would frustrate,
Yes.
and it will be improving the plaint.
Yes.
That's what you, and any judgment in support of that. On that day,
Well, my judgment is already on record.
page number.
Yes, Your Lordship.
But then you just provide me with the one page.
I understand the learned friend is referring to judgments under section 230, which says that a suit can be filed against a disclosed agent of a disclosed principal.
But that is on the merits.
That is not the merit.
Lord, why it is important for this application also? Lord, because those applications say,
No, Mr. Counsel.
Yes.
What I am saying that today we are considering his application. That whether his application is required to be considered first by granting herein to order 7 to 11 application or not. You say that is a great prejudice which has been caused to you by narrating the facts. And for that purpose, you say the facts are very important. You just jot down or give me the page on which you have stated this fact, that the situation will be so irreversible that you will not be having you will be having the irreparable loss, and therefore his application may not be considered.
yes, I will.
So
Although, my Lord, I have already filed a reply to that effect only to his application OJCA 1 of 2024. I've already filed that. I've already done it. But what I can do is, I can give a brief 1 page or 2 page,
only
one page.
with the pagination, I'll
Yes.
independently look into and then I'll pass appropriate.
So, my Lord, can I take the liberty of passing that along through my local counsel? Your Lordship? Yes.
That is, by what time you will be able to do? Then I'll fix it. Not today. I am also, I'm not even expecting it today. By 1 week?
By 1 week.
So
I'm traveling for a whole week, 9 days.
So by 10 days?
Lord,
Or so that
would it be in the middle of the month of July? Somewhere in the middle.
some date in July.
In some date in July, probably these are to be taken up on Fridays only, I guess, Your Lordships.
Otherwise it won't be taken up. This I'll be placing on Thursday.
So, can I
Let it be Friday only, not because
Friday.
you have to travel back then
25th.
25th. 25th. Absolutely.
At the moment, 25th July. But by within period of 2 weeks, you will be
Yes,
giving me
by
the
11th, I should be able to submit
and
the note.
only your submission on his application that why it should not be heard first.
As distinguished from the merit of my order.
But Your Lordship, I would have to touch some things.
Facts. So facts you
Facts as well as the law. Because because his argument is that I will be prejudiced. And my argument is that he will not be prejudiced. For that, I would have to refer to law. Because only my lords have also said give law. So I would have to refer to law.
We'll see.
Obliged, Your Lordship.
I'll look into. Let me have brief idea about, because it is impossible to run through every page.
I can understand. Weary lies the head that wears the crown.